they determine.
Okay. You both are under arrest for obstructing government operations.
What happens when police arrest the attorneys representing a client on the courthouse steps minutes after a hearing ends? Not for anything the attorneys did wrong, not for any crime, but because they refused to hand over evidence that a search warrant didn't authorize anyone to take from them. And what happens when the district attorney, moments later, publicly accuses those same attorneys of possessing child pornography in front of onlookers before any investigation is complete? This encounter raises questions about the limits of search warrant authority, the weaponization of obstruction statutes, and what accountability actually looks like when the legal system is turned against the people trained to understand it. On February 23, 2017, attorneys Victor Reville and Megan Garcia were leaving a courthouse in Blount County, Alabama, after representing their client in a protection from abuse hearing. Their client, who we will refer to as the defendant throughout this video, had told his attorneys that he received explicit photographs and messages from his wife after she filed for the protection order, material the defense believed supported his innocence. After the hearing concluded, the defendant handed 2 out-of-service cell phones to Garcia, who placed them in her satchel to be reviewed as potential defense evidence. As the 3 of them stepped outside, deputies Sue Ashworth and Brian Ratliff of the Blount County Sheriff's Office were waiting. They had a search warrant, but as we will examine closely, the scope of that warrant matters enormously to everything that follows.
His vehicle.
That's correct.
So he has given the phone that's on his person.
Okay, I have video of him handing the phone to you. You handing the phone to her. It's in the satchel right now.
You know, you all do have that, but that is not on. When you all
No, I'm
came
out
on
here
him
at the courthouse
to serve
with
this
Brian
search
on the
warrant,
search
that was
warrant.
not on his person. So you all are not entitled to that.
Okay. Well, all right then. We'll go the other route to get that other phone.
All right, you just gotta apply.
Okay, we're standing here and we have it on video that he had it.
The applicable legal frameworks here are the Fourth Amendment, which governs the scope and limits of search warrants and protects people from unreasonable seizures, and Alabama Code Section 13A 10-2. That is the obstruction of governmental operations statute under which Reville and Garcia were ultimately charged. Both will be applied directly to what the footage shows.
Turn this off.
Deputies Ashworth and Ratliff presented Reville with the search warrant and proceeded to search the defendant's person and vehicle. Reville reviewed the warrant carefully. What he identified in that moment is the legal foundation of everything that follows. The warrant authorized a search of the defendant's person and his vehicle. It did not authorize a search of his attorneys. It did not authorize a search of Garcia's satchel. It did not authorize seizure of property that the defendant had already transferred to a third party before the warrant was served. Under the Fourth Amendment, search warrants must particularly describe the place to be searched and the persons or things to be seized. This particularity requirement exists precisely to prevent general exploratory searches. A warrant authorizing a search of one person does not extend to everyone in that person's vicinity. When Deputy Ashworth demanded that Reville produce the phones from Garcia's bag, she was demanding compliance with an authority the warrant did not grant her. Reville stated this clearly and calmly. He reviewed the warrant, identified its scope, and informed the deputies that the phones were no longer on the defendant's person and that the warrant did not extend to his attorneys. This was not obstruction. This was an attorney correctly reading a legal document and acting on it. Deputy Ashworth then made a call to the district attorney's office seeking guidance on how to proceed. This call is significant. A reasonable officer who was uncertain about the legal authority of a warrant had an appropriate path available. Stop, consult, and if necessary, obtain a new warrant specifically authorizing seizure of the phones from the attorneys. That path was available. It was not taken. Instead, Ashworth informed Reville that she was detaining him and Garcia until she could determine the next course of action. At this point, the detention may have had a narrow legal basis. Under the exigent circumstances doctrine, officers may, in limited situations, act without a warrant when evidence faces imminent destruction. If Ashworth had maintained the detention and immediately pursued a proper warrant for the phones in the attorney's possession, that approach might have survived legal scrutiny. Courts have recognized that digital evidence can be destroyed quickly and that urgency can sometimes justify brief warrantless action. But the exigent circumstances doctrine has strict requirements. It requires genuine urgency, and it requires that officers take the least intrusive action necessary, securing the scene and obtaining a warrant, not arresting the people holding the evidence.
Okay.
What happened next forecloses any
okay.
exigent circumstances argument. After a second call, Ashworth informed Reville and Garcia that they were under arrest, not detained, arrested for obstruction of governmental operations under Alabama Code Section 13A10-2. The moment the situation escalated from detention to arrest, any exigent circumstances justification collapsed. An arrest is not the least intrusive action available. It is among the most serious deprivations of liberty law enforcement can impose, and it requires probable cause. Alabama Code Section 13A10-2 states that a person commits obstruction of governmental operations if, by means of intimidation, physical force, or interference, they intentionally obstruct the administration of law or prevent a public servant from performing a governmental function. Every word of that statute matters. Intimidation, not present. Physical force, not present. Interference. Reville and Garcia stood on the courthouse steps and verbally declined to comply with an order the warrant did not authorize. Verbal non-compliance with an unlawful order is not interference under any reasonable reading of that statute. It is the exercise of a constitutional right. The arrest warrant application filed by Deputy Ashworth stated that Reville and Garcia were in possession of an item subject to the search warrant and refused to hand it over. But the search warrant, as written, did not make the phone subject to seizure from the attorneys. The factual premise of the arrest warrant was incorrect on its face. What followed the arrest compounded the legal and ethical violations significantly. Reville and Garcia were handcuffed and held outside the courthouse in public for approximately 30 minutes before being transported to Blount County Jail, where they were booked and held for roughly 4 hours. Each paid a $3,000 bond to be released. On the courthouse steps, Assistant District Attorney Scott Gilliland publicly told bystanders that the attorneys were knowingly in possession of child pornography. Approximately 3 weeks later, District Attorney Pamela Casey made similar statements to the press, calling the attorney's conduct not only illegal, but unethical. These statements were made before any investigation or judicial finding established anything of the sort. At the time these statements were made, Reville and Garcia were criminal defense attorneys who had declined to comply with a search warrant that did not authorize what deputies demanded. The public accusations went far beyond that.
Can you watch these folks? And I will go down and search the automobile.
You can pull your car out here and go put them in the back, whatever you want to do.
That's up to you. If you want to do that.
Right, this is y'all's gig. I'm just doing that.
Deputy Rattler, yes, I want to make sure that you know from our position was that this search warrant, this warrant was given to him after he gave us some things for us to use in his defense. And so we did not do anything to keep you all from doing you all's job. Now, if you all want to
I'm out here
this
with
satchel and go
the
through
sheriff's
and do it,
office at the courthouse.
we're not preventing you from
doing a search warrant on the car and making
so I just wanted to
I'm out here just videoing.
And I understand your point, but understand ours. From the moment he's entered the courthouse, he's been under surveillance. Okay? For the reasons of this search warrant. Alright? I've sat here and watched you and him and her.
Can't wait to get about 10 or 15 minutes. I'll be ready.
You looked up. Matter of fact, you did look up at the camera 2 or 3 times. He pulled the phone out and handed it to you. You handed it back to him. He was fooling with, I'm guessing, a password. And after a short period of time, he handed it back to you. You handed it to her. She put it in here. Okay? That is evidence for this search warrant.
And you agree with me that you all served this search warrant on him subsequent to that, after that, right?
Yeah.
After we left out the building.
Yes.
And would you agree that we are not preventing you from getting to the building?
I mean, we could sit here and split these hairs all day, okay?
The criminal charges against Reville and Garcia went to trial in March 2018. Judge King acquitted both attorneys on all charges, finding that the deputies had misread the authority of the search warrant and that neither Reville nor Garcia had physically prevented the deputies from doing anything. The criminal verdict was unambiguous. The federal civil lawsuit is where the legal picture becomes more instructive and more complicated.
You know where Joe is?
Reville and Garcia sued the deputies, the district attorney, and the assistant district attorney under 42 U.S. Code, Section 1983, for Fourth Amendment violations, and separately for defamation. The district court initially found in their favor against the deputies on the false arrest claim. On appeal, however, the 11th Circuit Court of Appeals reversed that finding in July 2023, granting qualified immunity to deputies Ashworth and Ratliff. This outcome requires careful explanation because it is widely misunderstood. Qualified immunity does not mean the deputies were right. The 11th Circuit applied the standard from District of Columbia versus Wesby, decided in 2018, which asks not whether the arrest was lawful, but whether a reasonable officer, looking at the legal landscape at the time, could have interpreted the law as permitting the arrest. The court found that given the factual complexity of the situation, phones observed being transferred, and a valid warrant for the defendant in close proximity, a reasonable officer might have concluded the arrest was permissible. That is a very different conclusion from saying the arrest was constitutional. It means the law was unclear enough that the officers avoided personal liability. The underlying conduct was not vindicated. The defamation claims against District Attorney Casey and Assistant District Attorney Gilliland survived qualified immunity. The court held that state agent immunity does not protect intentional defamatory conduct. The Reville case terminated in February 2024, consistent with a confidential settlement on those remaining claims.
I'll look on what I think.
Can you stay out here?
Yeah. Come home, man. Y'all been busy? Yeah. That's what it's always on. I hear you on the radio all the time. I hear you on the radio all the time.
Hey,
Go all over God's green earth. I do.
I'm down at the courthouse, and I'm on the north side of the courthouse, and I've got two people that I've arrested down here.
Down the rest of here.
Two transport vehicles. That's correct. Yes.
I'm not saying anything.
That's for your customer. You want me to call my office or another one of the lists? Does it say anything over there?
He's not interested. He's not interested.
Don't look good.
Oh, it ain't.
Corporal? Douglas is a liar.
Yeah, right. I just swim here.
Sorry.
I am my own person.
I was gonna try to help him out.
How are y'all?
All right, how are you?
Okay. Morning, gentlemen.
Good morning.
Almost afternoon.
Lunchtime.
Wow, notice it. I don't know, but I don't know, on phone. They've got video of him using the phone. I don't know exactly what word it was.
Well, why don't you just go get it right quick? I mean, there's probably a judge in it.
That's what she said. She said, if you don't give me the telephone every time you don't get a search warrant for the telephone, they said, we're not doing that. They arrested for obstruction. His argument is that they were served with the search warrant subsequent to him giving the phone to her, so they're not trying to. They weren't actively obstructing. You know, so, like, he gave them the cell phone before they got served with the search warrant, or he got served with the search warrant. She asked for the cell phone to make this, you're not getting anything that's not on this person. That just ain't make it to the Supreme Court.
They don't make it that far. Whether I sit on that.
It's dramatic.
Long day. Such a headache. Yeah, it is. Carry around a couple bears. They get heavy.
Yeah. I don't know.
Thank you.
Thank you, sir. Appreciate you. Dear Lord. For real, right?
130K, before taking 1130.
Those ones that are now knowingly possessing child pornography, that was a bad mistake. Nope.
But
He's funny.
the,
He's good at what he does.
yeah, I wish he was over.
Never even thought twice about it whenever he's a defense attorney. They just see what he's done as a prosecutor.
This is 126.
Just on right there, so you know that you could child pornography. Know not what he had going on.
When available, 1095 Grandview Trail, Laundry Room, Miller.
Have an ETA on deputies around the courthouse next quarter.
We would love for them to be able to do that. We would love for them to do that.
No, they're going to.
I don't think they're a flight risk on a 5 minute. I think we need to leave.
No, I'm sorry.
I'm good.
Wonder if Jude's ready. You're up, Jude's ready.
She may already be out there. She didn't get any service. By herself?
There's gun going. Gun is 20 minutes late.
Yeah. No, she's not here. Oh, yeah.
Dispatch 106.
They got video and everything here. Of the front right here.
106.
They've got video of the front.
10-282 by 21. Also 111 requesting an ETA for
Yeah, right now.
Okay.
Let's go.
Yes.
about 5 minutes, taking about 8.
Three things viewers should carry out of this video. First, search warrants are bounded documents. They authorize specific searches of specific people, places, and things. A warrant for one person does not extend to everyone near that person. If you are ever in a situation where an officer claims a warrant covers something or someone it does not explicitly name, you have the right to say so clearly and calmly, as Reville did. Second, verbal noncompliance with an unlawful order is not obstruction. Under Alabama Code Section 13, A10-2, obstruction requires intimidation, physical force, or active interference. Similar statutes in most states use the same basic framework. Standing still and declining to hand over property that an officer has no legal right to demand does not meet that standard. Knowing that distinction matters. Third, qualified immunity does not mean the government was right. It means the law was not clearly established enough at the time to hold individual officers personally liable. Those are fundamentally different conclusions. When officers receive qualified immunity, the conduct itself has not been approved. Only the personal liability has been shielded. The path for accountability, as this case shows, often runs through defamation and civil claims rather than the Fourth Amendment alone. The legal system has safeguards. This case shows both how those safeguards can fail and how eventually they can hold.